Hi everyone, my name's Stuart Lester. I'm an intellectual property lawyer at Mish Kondareya. I specialize in all areas of intellectual property with a particular focus on brand protection and brand enforcement. I'm also part of the Mishcon Sport and Esports group. In this short talk, I'm going to be speaking to you about third-party trademarks in video games. I'm going to cover two recent cases which have brought this topic into focus. One of the emerging battlegrounds for brands owner is video games, and particularly with the growth of virtual reality applications in esports. But it also represents a massive opportunity for brands to license their IP and to make more money. For many game publishers, one of their main objectives is to make their game look as lifelike as possible. The reason gamers love to play FIFA football game is because it offers the players a chance to come as close as possible to that feeling of what it's like to be a professional sports superstar. In order to do this, FIFA spends hundreds of millions of pounds to license intellectual property and many more millions to digitally recreate it. For example, FIFA licensed lots of IP owned by the Premier League, including even things like patches for referees and assistant referee uniforms and the Premier League logos. FIFA also licensed the IP to every Premier League club name, their kit, their crest, their stadium. And that's all in the latest FIFA series. All 20 Premier League stadiums appear in perfect detail, and each Premier League team has its own anthems and songs recorded. And that's all in the game. This is an example of where a games publisher and a brand owner can both benefit. The game gets to use the IP and so makes the game incredibly lifelike. And the brand owners get their name in front of the faces of millions of players, and they also get a big chunk of money. In fact, EA Sports' deal with the Premier League from last season until the season of 2024-25 is understood to be worth well in excess of $30 million per year. But not all publishers, like FIFA, actively go out and make deals with the brand owners. Some games include third-party brands in their games without permission, and this is where disputes can arise. The question is, do they need to obtain permissions or not to use those marks in their games? Well, in a US case last year, vehicle manufacturers AM General made a claim against the creators of the Call of Duty game over the use of Humvees in their games. As I'm sure you're all aware, Call of Duty is a first-person shooter video game franchise that sold hundreds of millions worldwide. And Humvees are military vehicles used primarily by the US Army. So AM General claimed that by featuring the Humvee trade dress, which is another word for the visual appearance of the vehicles, and also for including the trademarks for Humvee within the Call of Duty game, the creators had deceived consumers into believing that AM General had approved or licensed or sponsored the game in some way. Now, this went to the US District Court for the Southern District of New York, and they held that the depiction of the Humvee vehicles within the Call of Duty games, including the reproduction of the trademarks, did not infringe those trademarks. In granting a judgment against the claim, they said that while it is metaphysically possible to have produced video games without the presence of the Humvees, they increased the game's realism. The game included the US military, and the Humvee vehicles are used by the US militaries and therefore fulfilled a genuine purpose within the game. Obviously, this is unique to US law, but it's possible that a UK court would have reached a similar outcome, though for probably different reasons. And to explain that, I want to talk about a final case in the UK that has some parallels with the Humvee case. And this relates to the popular video game Football Manager. So this is a case between Manchester United Football Club and the makers of the popular Football Manager game. Last year, Man United sued Football Manager, claiming that the inclusion of the Man United name, Manchester United name, within the game as one of the teams that players can manage, that infringed the EU trademark for Manchester United because Football Manager had not asked for permission or paid a license to use the trademark. More unusually, there was also a second claim that the exclusion of the club crest within Football Manager amounted to an infringement of the EU trademark for the crest as well. Football Manager actually doesn't use Man United's logo, It's just a simple red and white striped logo. So this claim is based on a pretty novel argument that given the game uses the team name and all the real names of the players and staff, that users of the game would expect to also see the official club crest. And so by not using the club crest intentionally, because Football Manager, because there's copyright in the logo, and so Football Manager would have to pay for a license to use that. So they'd intentionally not included it, and that deprived Man United of the right to make money from licensing opportunities. The case is a little bit difficult to comment on in too much detail because it's still ongoing, and it's still at an early stage, in fact. But it seems that for Man United to successfully argue that the use of their name infringes their trademark, we think they're going to have to convince the judge that the average consumer playing the game would think that Manchester United had licensed the use of its trademarks within the game. As we've seen in games like FIFA and PES, it has long been customary for makers of football simulation games to obtain licenses to feature football teams in the game under their real names. And we know that, and we know that gamers are probably aware of that, because over the years, there have been some team names or countries, players' names that have not been included in FIFA. For instance, in the current FIFA, Juventus, Italian giants Juventus, are called Piedmont Calcio. And that's because they didn't get the license from Juventus to include their name within the game. So gamers of FIFA probably realize that there is licensing going on. However, does the same apply for Football Manager? Football Manager is a game that's been in existence for a very long time, and it's got a very loyal fan base. And perhaps they've got a different expectation when it comes to licensing and the licensing and use of names compared to FIFA, for example. Perhaps that practice has not built up in the same way, and we have to draw a distinction between these types of games. Also, as the makers of Football Manager pointed out in their defense, their game has been using Manchester United's name in different versions since 1992. So this is the first time that they're complaining about it. It's going to be a really interesting case to hear the outcome certainly from a UK legal perspective, because if Man United succeeds in its claim over the use of the club name, then games like Football Manager and other video games will have to either buy a license to use the names of those real teams, or they'll have to adopt a different strategy, which is to use fake names completely. And that latter approach is probably not going to sit very well with the gamers of Football Manager, who would, it wouldn't be such a great experience if they were managing Man Red, for example. And if Man United also succeeds on its claim that not using the club crest infringes that trademark, which is a pretty novel argument, but that could force game publishers to pay for licenses for trademarks which, they're not really even using, or that they don't want to use. On the other hand, if Man United are not successful, then this lucrative industry that has been built up under which companies like FIFA and PES pay a lot of money to license IP could be dealt a bit of a blow. Certainly, there'll be smaller gaming companies or other platforms like fantasy football games or betting operators that might seize upon that opportunity to use club names without permission and without a license. Of course, the eventual decision could also simply highlight that this is quite a unique case where Football Manager turns on its own facts. We've got a game that's been built up for 3 decades where the practice of licensing has simply not evolved in the same way, and the gamers of Football Manager and those loyal gamers don't have the same expectations as other games. And that can't be applied to newer games where there's not such a history and fan base. So in closing, as we've discussed today, the use of IP in video games is incredibly valuable for the game publishers in order to make the game as realistic as possible. But there's also an opportunity for brand owners to get their products and brands out to a large audience. This is not something that's particularly new. For years, skateboarding brands appeared heavily in Tony Hawk's series, for example. But with the immense popularity of gaming and the increasing level of interaction with consumers, and their interaction with those video games, brand owners are becoming increasingly aware of the value and the opportunities that they've got to license their IP in all different kinds of ways. Therefore, for content creators, they should really be mindful of the potential need to obtain consent whenever they're using third-party IP, whether that's in their virtual world, in esports games, or whatever. And that's particularly the case where the public might believe that those brand owners have given their consent or have some association with the game. And that brings to an end this talk on third-party trademarks in video games. If you have any queries, please do get in touch. Thanks for listening.